My kids are really excited. They think I'm going to be up here doing something. Look, we want to watch. I'm like, that's cute, but I'm not going to be. Go ahead.
You're getting the mics. All right, I think we're ready. Okay. All right, welcome everyone. Thank you for attending tonight's event. Everyone here knows me. My name is Taylor Fontenot. I'm here on behalf of the Family Law Section of the Lafayette Bar. I'd like to thank the Lafayette Bar Association staff for helping us put this event together, and to the candidates for agreeing to participate. I'd also like to thank the members of the Family Law Section who submitted questions for tonight's event. This was put together on short notice, but I believe this is a very important race for the families of Lafayette, as well as the attorneys that represent them. Hopefully tonight's discussion is going to assist some of those still undecided voters out there. As far as format, my hope is that this is not so much of a debate as a question and answer session. I'm going to pose some questions. There will be some questions asked by the members of the Family Law Section, and each candidate will be given an opportunity to respond. We're not going to have a strict timer, but generally speaking, let's try to keep them to 2 or 3 minutes each, please, because we got 3 people and we got about an hour. Before we begin, this is being hosted by the Family Law Section of the Lafayette Bar Association. Either the Family Law Section or the Lafayette Bar Association has endorsed a candidate or expressed a view on any of these issues. Before we begin, I think Caitlin has a short announcement. Candidates for 15th JDC Division N Family Court Judge. Nearest to me is going to be Ms. Susan Thayall, Ms. Donna Reniger, and Mr. George Knox. All right, getting started. I want to give each of y'all a few minutes to just start out by telling us a little bit about yourself and why you're running for Family Court Judge. Start here. Sure.
Hi, I'm Susan Thayall. I'm an attorney here in Lafayette. I've practiced law 35 years this month. When I first started campaigning, I was saying 34 years. I looked at my Supreme Court certificate the other day and saw it was October 11th of 1985, and so here I am. My entire practice has been focused on family law. The very first case that I tried was a custody case, and that's what kind of sucked me into this area of law. When I was in law school, I had no intention of practicing family law. But when I saw the kind of impact my work could have on a family, it's what I've concentrated all my efforts and energy on since then. I'm a board certified family law specialist. There are only 77 specialists in the state out of about 22,000 lawyers. There's another one in the room, one of our family law section members who recently passed the exam and will be certified as of January, so that number will increase. But to me, it exemplified, taking the exam and becoming board certified, exemplified my commitment to this area of law. I'm also a former family court judge. I served for 3 years. I love this area of law. I believe that I'm good at it. I believe that with the experience that I have, that I can serve our community. And that's what being a family court judge is all about. It's about service to our community and trying to do what we can to serve children's best interests.
Good evening. My name is Donna Reniger, and I'm currently a partner at Visa Felder and Reniger. began my practice as the domestic abuse assistance attorney 28 years ago, Susan, I'm catching up. I was practicing in Alexandria under a Louisiana Bar Foundation grant representing exclusively victims of domestic abuse. Couldn't wait to get back to Lafayette, so as soon as there was an opening here, I moved to the Acadiana Legal Services office here in Lafayette. I've maintained a family law practice. From some portion of my practice has been family law for the entire 28 years I've been practicing. I'm running, I'd like to tell you why I'm running because that's important to me. Number one, I think as a young lawyer, I talked about being a judge, and then you get into your practice and you begin litigating, and I enjoyed it. Was lucky to want to be a lawyer, got there and got to practice and loved it when I got there. But a number of family law practitioners approached me actually when I was president of the State Bar Association about 3 years ago and asked me if I would consider running. And it's the first time I thought about it in a number of years. And there were 3 factors I considered when I was trying to decide whether or not this was the right path for me. Number one, what qualities do I have that I can bring to this bench that will serve the community? And those qualities, I believe, are even temperament, an excellent communicator, especially listener. I think I'm passionate, I'm dedicated, I have a great work ethic, and I've been working in this area of the law for the entire 28 years I've been practicing. Second area I thought about was, would I like it? I have to be honest, I want to enjoy it when I get there. And I'm one of those people that enjoys litigating. Hand me a file, tell me which side's paying me, and I'll go make an argument. But I think I noticed in the history of my practice that I tend to change it about every 5 to 7 years. I'll go from domestic abuse assistance attorney to a general family law practice, to an expanded general litigation practice as an associate, to a partner at a law firm. And I'm looking forward to that change, and I think it's something I'd be good at. The third and probably the most important reason, or I should say, analysis I did about whether I ran, was could I let 2 attorneys stand in front of me, one of whom I'd had great relationships with throughout the course of my practice, and another that I had not had quite such a great relationship with. And could I let that experience go? And could I see the facts? And I'm confident I can assure all of you in here and everyone watching that I can do that. So those are the 3 reasons I'm running.
Good evening. My name is George Knox. I have probably told most people before, I'm very proud of the fact that I'm born and raised in what was in the village of Youngsville. Went to Green Team Elementary School, went to Youngsville Elementary School. Was proud to actually be in the first graduating class of the Episcopal School of Acadiana. That was in 1983. 1983 was a big year for Youngsville. Youngsville actually became a town. Governor Dave Treen came down and proclaimed that from this point forward, Youngsville would be a town. Graduated from ESA in 1983 in the first graduating class. I was at the top of my class. I got a National Merit Scholarship. And unbeknownst to me, my dad had decided that I would go to Texas A&M and following his footsteps. He graduated in class of 51 and following my grandfather's footsteps, who graduated in 1914. Went to A&M, graduated in 1987. Upon graduation, I was also commissioned as an infantry officer in United States Army Reserves. I was accepted to LSU, the Paula Mayberry Law Center, so I attended LSU. Actually, after my first year of law school, Uncle Sam informed me that I need to go to Fort Benning for about 19 weeks of officer training. So I did that right after my first set of exams in law school. I came back, finished, graduated from LSU in 1990, practiced in Baton Rouge with 2 great individuals. One of my bosses, Tony Marabella, is now a criminal district judge in Baton Rouge. My other boss was Hilla Moore, who is now the district attorney for East Baton Rouge Parish. I practiced in Baton Rouge, like Baton Rouge, but at heart I was a Youngsville boy. So I moved back to Youngsville in 1993. Got married, ended up having 3 beautiful boys. In 1995, I ran for what was then the Board of Aldermen for the town of Youngsville. Served on that for 4 years. In 1995, I actually ran for the Parish Executive Committee for the Republican Party. That year following that, I also served on the State Central Committee for the Republican Party. I've been very active in Republican Party politics. I shared with people the other night, I remember when Judge Katie was a law clerk for Judge DePlanche, and she made the commitment to our community to run for family court judge. And I walked door to door for Phyllis. I raised money for Phyllis, and she was the right person for the job. In terms of my experience, I've been practicing for nearly 30 years. I've been doing primarily family law the entire time. For the past 18 years, I have had the pleasure of being the city attorney for the city of Youngsville. As you can imagine, that brings me a lot of pride in terms of having grown up in the cane field with no subdivisions, 2-lane highways, some gravel. I've seen Youngsville go through a lot of growth, and it brings a lot of pride to me. In terms of the reasons why I want to run and why I would like to seek this position, is from my perspective, I want to bring my experience not only as a practitioner, but as a parent. We have 3 beautiful boys. My oldest, Rob, graduated from Texas A&M in 2018. He's now back here getting his master's in business. I have a junior, my next one, my middle son, Jack, is actually a junior at ESA. He's 17. I tell everybody he's my work in progress. And they have a little brother, Alex. Alex is going to turn 15. He's at Youngsville Middle. And I've shared with people, and I'm not always the most open about my personal life, but I want people to know that when they come before me, I've gone through a lot of the same struggles that parents go through. When Jack was a 6th grader, he was diagnosed with Crohn's disease. I didn't know anything about Crohn's disease. I just knew that he was having surgery after surgery after surgery. But he made it through that, and I'm happy to say that he does his treatments every 60 days. He's a happy, healthy boy. Plays sports at ESA, maybe cuts up a little bit too much at ESA, but he's had a great time. Same for my youngest, Alex. When he was 5 years old, he was diagnosed with autism. Same thing, I had represented clients before with children who had autism or special needs, but it's entirely different when you walk through that walk as a parent. And again, we had so many wonderful people with speech therapy, occupational therapy, and I have a sensitivity to that. And I think that what I always hope, and I hope people would always say about me, is that again, when people come before me as a judge, I'm the same boy from Youngsville. I may have gone to school in Texas, I may have gone to law school in Baton Rouge, but I'm still the same guy that grew up in Youngsville. And I want people to know that, I've walked a mile in their shoes, just to be in this room. We all have friends. A lot of us have been in that same position. And I think it's our jobs as judges to focus on the best interest of the kids and get them through this system. I don't like cases to linger on for 3 years. I like to keep the children out of the middle and get parents past it. It's as Donna said, when a client comes in, you get the file and you're immediately advocating for your client. Well, I think it's the judge's role, first and foremost, and Louisiana law tells us that it's to advocate for the children. It's what's in the best interest of the children. It may not be in the best interest of Donna's client. It may not be in the best interest of George Knox's client. But the judge has to separate themselves and focus and transition on what's going to be the best for these children. And I think that having practiced for 30 years and having been a parent for now 24, about to be 25 years, I totally understand that process, and I can believe that I can bring my experience to help families through that process and hopefully get them in our system and out of our system.
It might be
Is that your
switch.
Is that your artificial way of telling me? Is that your artificial way of telling me I'm talking too long?
It is about.
Okay, but again, my hope is that we can get children and families through our system. As practitioners, we've all seen the rise of substance abuse, domestic abuse, mental health issues. way more so than when I originally started practicing in 1991. And I think we can do a much better job addressing those issues and trying to heal these families. You know, children are innocent. Even the most abusive situation, children put both parents on a pedestal. They
Sorry,
want.
George, can I interrupt one second? We're actually gonna get to some of that.
Okay,
We can maybe
well,
work
just,
it out.
again, my hope is that, I would like to bring my legal experience and my family experience and help the family court go forward.
All right, moving on, we'll start, let Donna start out this one. I had a number of questions about changes. People are, some of the section members are wanting to know, I'll do this one in two parts. One, do you feel there are any changes that need to be made in family court? If so, what would you propose? And something that might be a little more under your control, what's the biggest changes we can expect as we transition from Judge Fitzgerald's court to your court?
Sure. I think changes can be made. I think we can always look at any system and become more efficient and more litigant friendly. What comes to mind first and foremost to me is the Clear Start program. I've had clients that are both in it, and I've had the non-substance abusing party. I think that there are some issues. We have a number of issues. First and foremost, my client that's not abusing substances has to pay me to go every 90 days for a review. And that works okay if you have somebody that gets clean in 6 months, supervision lifted 6 months later, they're out of Clear Start. It doesn't work so well if you have somebody, the other parent struggling, where you have a positive test and you have to start over. And it can drag on forever. So I'd like to address that. Number two, I think the notice in Clear Start is a little short, in my opinion. For those of you who practice in it, as you know, you have to give a 10-day notice for the Clear Start program. If you're going to request a lifting of supervision at the review hearing, sometimes I need more than 10 days to get my evidence together if I'm going to object to that. It may not have anything to do with a positive or a negative screen. It may have to do with an incident during the exchange of the child. It may have, and I need time to get that evidence together. So I think I would like to propose a slight increase in that. As far as I'm trying to stick to 3 minutes, I think that there's a delay right now in hearing officer conference dates. I didn't see that as badly before COVID or before Andre Doge's new position as commissioner or before Vanessa Randall's terrible loss. So I don't know if that is going to be a lingering problem or not. But I think if financially feasible, the addition of any personnel that could help make the system faster or more litigant friendly would be great. And then what changes would you see? Okay, I like the dependability of Judge Fitzgerald's schedule. I know on a Monday of a merits fixing week, it's only going to be pre-trials. That's what I want to pledge to keep going. I know on a rule day, unless it's very short, I'm not going. I want to be able to tell my clients that they're missing work. They're sitting there for days. I like that. I intend to continue that. I'm going to pledge to render judgments from the bench. I know it's hard. I don't know if I can start doing it daily when I first get in there because I don't know what I'm hitting. But I think that is incredibly dependable for my client. And it's so reassuring for me to tell them within a day, 2 days, sometimes he takes a weekend. We go back on Monday, but that's very reassuring. I intend to keep court at 9 a.m. And the other thing I would like to mention, and I'm sorry I'm going back, but I've never seen the statistics on Clear Start. Of course, we all have anecdotal stories about how it works great or it doesn't work, but I would love to know if we're keeping statistics. If we are, how many people are we helping? How long are they going through it? How much is it costing? I think if you're willing to have a program, you ought to be courageous enough to keep stats on it to see if we're getting the bang for our buck. Of course, that's something that's yet to be seen.
You want to go ahead and repeat the question? I was listening intently to Donna's answer. I think I know the question.
Yeah, sure. The question was, do you feel there are any changes that need to be made in family court? If so, what would you propose? And then the second part is, what changes can we expect as we transition from Judge Fitzgerald's court to?
In terms of changes, I think a couple of things. I think I would echo what Donna said about the Clear Start program. I think the Clear Start program was very well intended. I do believe there are a number of success stories. Again, I'm sometimes representing the individual who has the substance abuse problem, and we are welcome for the help, and I encourage them to focus on the help and get through the process. At the same time, I'm oftentimes representing the other person who doesn't have the substance abuse issue. And I guess some of the issues that I've seen, and maybe just comparing it to drug court, I think the drug court program that Judge Edwards and Judge Michaud and others started many years ago is an effective program. And one of the things I like about their program is it's a 3 strikes you're out. Sadly to say,
Promise I'm not doing
sadly to say, I've had cases, without naming the individuals, I've had cases where people were being monitored for 6 months, had supposedly gone through outpatient treatment, and then they come back positive with a test for heroin. Again, I'm not a mental health professional, but if you had supposedly successfully completed outpatient treatment and you come back and you test positive for heroin, there's an issue there. And I like the way the drug court has an incremental punishment. If it's a situation where someone's been in outpatient treatment, then I think the average person would say, well, clearly that treatment may have not had the effect that we wanted, and perhaps we need to have inpatient treatment. Oftentimes, when people repeatedly have positive drug screens, their monitoring periods aren't extended. It's, well, you tested positive this month, well, give me a next clean one next month, and then you'll be finished in the 6-month period. Again, 3 strikes, you're out. If you test positive once, guess what? You just bought 3 more months in the system. And because I think ultimately, for someone to want to get off drugs, they have to be invested in the process. They have to want to do it. And if there's not that system holding over their head, that their time's going to continue to be extended, it would be my hope that they would that would help the system. In terms of other things, and we talked about it way back when we formed the court with Judge Cady and Judge Cox. I was blessed to be on the committee that helped write all the rules, that helped set up the hearing officers, that came up with the family law affidavit forms. And through those discussions, we always talked about mental health evaluations. And I don't think the mental health issue was as big of an issue as it is now. But sadly to say, oftentimes these mental health evaluations can be upwards of $5,000 or $6,000 or $7,000.
I'm gonna do that one more time. I got one of those coming later. So
Okay.
on that.
So I would like to again explore the possibility of maybe having some sort of in-house mental health evaluation process. Maybe we could convince someone like a Dr. Bouillon, who has been doing custody evaluations for as long as I've been back in Lafayette, to consider doing that and make it affordable, because there are a lot of people that have very serious mental health issues. And if they don't have the $7,000 to pay for the mental health evaluation, it's not going to come out. The other couple of things I'd like to see happen is we do have an excellent commissioner in Andre Doge. And all of us have had cases against Andre Doge. He was a phenomenal litigator. And I would like to see us, and I think the judges have started to do that, I would like to see us utilize his services more. I realize he has responsibilities as a district commissioner, but I think that he could very easily handle community property partitions, again, assuming that the attorneys would agree. And all these measures would help to keep the cases moving through the docket. 2 other issues that I've seen, and some people say this is pie in the sky, possibly, but if you actually look at the statistics for Lafayette Parish, we have more domestic filings in Lafayette Parish than either of the other 2 parishes, and then every other kind of filing in Lafayette Parish. And to be quite honest, I think it was difficult for Judge Cady and Judge Cox to manage that docket with only 2 judges. I think it's a challenge for Judge Blanchette and Judge Fitzgerald to manage that docket and keep that docket moving. So my hope would be that we have new judges being elected in Acadia Parish. We have new judges being elected in Vermilion Parish. The volume of filings for domestic cases in those 2 parishes are very small. And I would like to see us make an approach to whoever is fortunate enough to get elected in Vermilion Parish and or Acadia Parish and say, look, how about you handle the cases involving children in Acadia and Vermilion, and you allow us to focus on our dockets here. Because if we can focus on our dockets here, we can get the cases moving through the system quicker. In terms of
Hey, I'm sorry, we just need to keep it moving a little bit.
did you want to ask about the Bill Judge Gerald shoes?
No, we'll circle back to that. That was about 6 minutes. I'm gonna get done in a few minutes. If you want to add anything, I'm gonna get Susan a second out of time.
No. Thank you. Compound question.
Yeah.
So.
Let me charge. So we have a compound question. Are there any changes that need to be made in family court? I think we all agree that we need some changes in family court. And any system is always going to benefit by looking at it with a different eye and by trying to implement changes. Now, change is hard, and some people resist change. I think we all do. It's human nature. But I think that it's going to require concerted effort and work by all of the family law attorneys with the judges. I think we need increased dialogue. I know that we have a liaison committee, but they've only been meeting with the judges twice a year. Typically, or when we first started doing that, we met 4 times a year. So every administrative week that family court had, we had a liaison meeting, and it was more than just a little half-hour meeting. I mean, because we have some deep-seated problems in family court, and it requires all of our input and all of our effort. And quite frankly, I think it requires more than just a select committee. I think it requires more participation by the family law section and more interaction with the judges to give us input. So I do believe that we need change. How will the transition happen between Judge Fitzgerald's court and my court if I were to be elected? I love the 9 o'clock start time. What I don't love is going into court and sitting around waiting for half an hour or 45 minutes to read a docket and then pre-trials. When I was formerly a family court judge, I had all the pre-trials prior to the start of court at 10 o'clock. We started as early as 7:30 in the morning, and we kept it to a strict 15 minutes. And if we start court at 9 o'clock, I can tell you that very few lawyers are going to volunteer for the 7:30 in the morning time. So my idea is to actually have pre-trial conferences on Fridays for the prior week. And require that if you want a conference, you do it on the Fridays. That'll do 2 things. It'll give you an idea of where the judge is leaning. And remember, a pretrial conference is where an attorney talks to a judge and says, this is what I believe I'm going to prove. And a judge says, if you prove that, this is more than likely how I'm going to be leaning. It doesn't.
Just a quick point of clarification. Are you discussing like pre-trials prior to a Monday merits
Correct.
week or Thursday rule?
Both. So, and in fact, I don't like merits weeks. And I particularly don't like merits weeks for Division M being scheduled on the same week as Division H. That's been a problem. So I would want pre-trial conferences on Fridays for merits trials and for rule days, because I think that will help things run more efficiently. I found that when I did that and I started early in the morning, by the time we got into court at 10 o'clock, there may only be 5 or 6 things to try. So the advantage to doing it on a Friday is being able to see what will settle and to then assign a time so that you're not waiting around the courthouse all day. As a private attorney, my clients don't like paying me to wait around. And I'm sure y'all get some of the same grief. It would be much more efficient if we could do it much before the actual rule day so that we can have assigned time. So That's one of the things that I believe that we need to do. And look, I would also like to explore changing rule days. I think that it creates problems to have Division H and Division M have rule days on Thursdays. I've seen too many lawyers running back and forth from courtroom to courtroom. It inconveniences your clients, it inconveniences lawyers when they've got to run back and forth to two courtrooms. And so I don't think that that should be a problem. And again, I'm open to suggestions. It's one of those things, as we're talking about changes that are needed, it's a problem that I've seen. If it's not a problem and it's just my misperception, I'm open to clarification. But I certainly think that it's a dialogue that we need to have. And again, the last thing I think is simply changing the merits weeks to merits days. I formerly did merits days. The disadvantage to that is if trials settle at the last minute, then you've got a wasted day. So it may be that there'll be a first and a second fixing. But in particular, I don't like the idea of having both merits weeks on the same week. I think that creates problems. One last thing, I think we have a real problem with discovery motions and motions to compel. I'd like to see about we may have to switch batteries or something. There we go. I would like to schedule quick fixings for motions to compel or discovery motions. Do it within 2 weeks. Give someone, the proper 10-day notice, but do it within two weeks. Set those on 9 o'clock on a rule day, so that we can try to have those very quickly, because there's a problem with discovery and with some of the basic submissions that are supposed to be exchanged at the hearing officer conferences. So I have lots of ideas. I think those ideas in conjunction with practicing lawyers, the hearing officers and the other judges, we need just more dialogue, and I think that we need to work together to resolve some of these problems.
Okay, I actually want to piggyback off Susan's answer to that. It was a question. Yeah.
One last thing. They talked about Clear Start. I think we have a separate question. Can I just quickly address that? Or are you going to go to a separate question?
I was going to go to the second one, but go.
All right. Clear Start was my brainchild in 2011 or 2012. When I left the bench in December of 2014, we did not have court hearings at that time. I believe that the way Clear Start is now set up is working inefficiently. I agree. I have clients who are non-substance abusing parents, and they're required to pay me to go, and I think that that's a waste of time and money. I've been told that all a substance abusing parent has to do is write something down on a piece of paper to ask for expanded visitation. That means I have to go to every hearing that they go to. I don't even know that it's efficient to have the hearings that we're having. I'm not quite sure that started. So while I believe it's a good program, while I believe that parents who are substance abusers need help, because children need their parents and they need happy, safe, healthy parents who can parent them. And someone who is seriously substance abusing, whether it's drugs or alcohol, cannot adequately parent their children. The whole idea of the program was to help parents so that children can have a relationship with that parent. We don't want the parents to drop off the face of the earth. So is there room for improvement? Yes. Do I have all the answers right at this second? No. But I think it's a worthwhile discussion.
Piggyback a little bit on Susan's response to that last question. So each might have answered part. You can start.
I started last.
No, this is kind of a continuation.
Oh, okay.
So the question I was going to ask down the road was, if elected, do you plan to continue the current practice of merits weeks and supplementing with special fixings? And second, what time are you going to open court? And will you be doing pre-trials prior like they do in Division 8 training? Susan answered that. I believe you answered part of that.
I answered part of that. I do like the merits weeks in division, in Judge Fitzgerald's court now. I don't mind. He does a combination of both merits and special fixings, and I appreciate that. But I mostly appreciate knowing that I'm not going on Monday. But if I go on Monday for my pretrial, I know exactly when I'm going that week. So it's the continuity that I appreciate as a practitioner, and certainly our clients appreciate. I've already forgotten the rest. Oh, rule dates. I'm happy to do pretrials. I will tell you what I've been toying with. We all had staggered hearings during COVID because we had limited numbers of people in the courthouse. If assuming that went a certain way and went well, I don't see why some of that couldn't be implemented. I would love to turn a terrible situation into something that may help clients with how long they're sitting there. So if there's some way to do a staggered rule, so you're not there at 10 a.m. and waiting till 4 for your pretrial, I think that would be great. I think, again, I like the continuity of pre-trying the cases on that day unless they're short. I don't want to take away merits and special fixings day. I think we all need them. We know how long we wait for them. So my goal is to be very efficient. I think on rule day, I can also be more efficient in dealing with explaining to pro se litigants, self-represented litigants, what needs to happen. I would not reinstitute the self-represented litigants rule day that Susan has spoken of. I think that's disparate treatment. And I think it's the equivalent of saying equal but separate. And I don't think it's fair for them only to have one rule day. And I think I can be efficient that day and make sure they're handled in a timely fashion. Did I cover everything, Taylor?
I guess with respect to that question, twofold, and I think that question originally originated in terms of Judge Fitzgerald and what things would you change about the way he runs his courtroom. I, for one, am a big fan of Charlie. I'm 55 years old. Charlie is a lot younger than me. He is a very hardworking judge. He is constantly reading everything that's submitted. Sometimes he shares with us that he gets up at 3:30 in the morning to read through stuff. It's that type of work and dedication that I think has been an inspiration to me. One thing that, and I agree with Don, the one thing that he does that I particularly care for is, he will render a decision. He'll take about an hour to gather his thoughts and review the evidence, and he'll render a decision. And again, it's this idea of giving a finality. People have to get this behind them. And the other thing I think that Judge Fitzgerald does particularly well, and Judge Blanchette too, but I recently had a case with Judge Fitzgerald, and he was given his reasons. I like that oftentimes he brings in cute stories about his own children. It was a contested custody case. It was a relocation case. It was where the little girl was going to stay in Lafayette or be relocated to Texas. And he ultimately decided that the child would relocate to Texas. And I know it was a very difficult decision for him. But throughout the trial, there was this suggestion that, the little girl acts different, or there's a suggestion that the parents are discussing the litigation, or she's acting differently. It was very heartwarming, and I think my client was very touched because he looked at my client, who happened to be the father, and said, I have an 11-year-old daughter. He said, when I come home from work, it's a hit or miss. It's a great day or it's a bad day. And sometimes that's just because that's a little girl and that's what they're going through. And it was interesting because I was watching my client when he was sharing those words and a light went off because they get focused on the litigation and both sides want to point the finger and suggest that they're doing things. And it was a sense of calm that came over this father to say, I have an 11-year-old daughter, and you're right. Some days on Mondays it's great, and some days on Tuesdays it's not, and it's a hit or miss, and you never know what's going to happen. In terms of the Merits Week, I agree with Donna. I like the Merits Week system. I like that in Judge Fitzgerald's courtroom and Judge Blanchette's. You come in on a Monday and you get an idea of are the cases going to settle or not, and then you're given instructions based on whose cases are going to settle out. Come back Tuesday, come back Wednesday, come back Thursday. With respect to the Thursday rule dates, while I wouldn't be opposed to considering another day, As a practitioner, I guess in some sense, I would hate to change the Thursday rule date. And the reason I say that is I handle cases in Opelousas. They know we have family law cases on Thursdays. I go to Iberia, I go to St. Martinville, I go to Franklin. Everybody knows Thursday's rule date for family court cases in Lafayette Parish. And the other jurisdictions respect that. So if we start moving ours to a Friday or a Monday or another day, then we're going to get in conflict with St. Andrew Parish and other judicial districts that have kind of grooved their hearing system around what we do. Because I am biased towards our system, but we're the leaders. And people come from all over this state to see how we do our family court system and what we do with our hearing officers. And I'll be quick. The last question, I personally like the 10 o'clock rule date. I get up at 5 o'clock. I make sure lunches are ready for school. I've shared with Judge Fitzgerald, my youngest obviously is not driving. My middle one is driving and maybe that was a mistake. Maybe I should take that license away from him. But, my little one, I still drop off at Youngsville Elementary every day with a lunch. And so by the time you stand in that carpool line and you drop off your child and you come all the way from Youngsville with the work traffic, it takes everything in my power to be there for 9 o'clock. And I think, in terms of, I think the same is for the litigants. The litigants that are coming before you, they have children. So they've got to get children on the bus. They've got to make lunches. They've got to do all these things. And so I like the idea of court starting at 10. I like that Judge Blanchette starts his pretrials at 9. So if I know I have to have a pretrial at 9, I make sure that, Alex's older brother helps out or somebody helps out and I can get my son to school and I can be there bright and sharp at 9 o'clock to try to resolve the case with Judge Blanchette. So I would like to see, although I'm not opposed to court starting early because I get up early every day. The 9 o'clock start time is just a stretch, and I think it's a stretch for parents. They're already emotional anyway to come to the courthouse and be ready to roll at 9 o'clock. So I would like to see that be at 10 o'clock.
All right, moving on. I'll let Susan get going with this one. If elected as family court judge, your most important job may be resolving contested custody cases. With revised statute 9335 and 9 as it relates to joint custody, what's your outlook on a physical custodial schedule? Assuming we have 2 fit parents and it's feasible given work schedules and distance, do you believe it's generally going to be in the child's best interest for there to be shared custody, or is it more commonly going to be better for the children to reside primarily with one parent and have that frequent and continuing contact with the other? If you can't answer specifically, how are you going to go about it?
Well, in a perfect world, kids wouldn't have to suffer and parents would never divorce. But that's not what we're faced with in family court. And again, in a perfect world, parents get along and can share children equally going back and forth. I'd actually like to start from a position of saying that children deserve to see both parents equally. Now, that's going to depend. Because if there's a parent who's not willing to make some sacrifices to maybe live nearby or who works offshore and cannot do it, but children need access to both parents. That's all there is to it. The sooner we can deal with that issue in the hearing officer process and in the court process, the better for children. When we're waiting 2 and 3 months to make decisions on custody, all it does is foments fighting between the parents. And once they start fighting, children become insecure. When parents aren't fighting and when parents are getting along and when they can see their children often, kids are more secure. That's all there is to it. When they see their parents start to fight and when things drag because they can't get into court and family court because it takes 2 or 3 months to get a hearing officer recommendation or a custody evaluation, that's when children suffer. So in an ideal world, I would like to see both parents have as much time with the children and an equal sharing of time if possible. It's not always possible. It's going to depend on the facts of every situation.
The way I read 9335 is that there are two modifiers to shared custody. One is to the extent feasible. I understand that your question assumes it's feasible. And number two is the best interest of the child. Because you have a modifier that's in the best interest of the child, I don't know that you can start with any presumption that I think may be best. It's got to be based on the evidence in that case. Does someone work 24 hours? Is it a nursing shift? Does someone have to go out of town on short notice? So I don't have a preference for either. I wouldn't read it as that. I read it, of course, it's best for the children to be with both parents. But I believe that modifier is in there to allow us to make that assessment, that proper assessment for each case. Does that answer?
I think I would to some extent echo what Donna just said. I do think, while you always take a look at shared custody to the extent that it's feasible, the overriding factor is whether or not it's in the best interest of the children. And I really think each and every case revolves around its own unique set of facts. I have clients that work offshore, 14 and 14. Well, for them to come forward and say they want their children 7 and 6, that's not feasible. That's not feasible because you're not here. Sometimes you have cases that come before you where both parents are working and both parents are equally sharing in the responsibilities. Sometimes you have families that come before you where only the husband is working and the wife is not working. Sometimes you have cases before you when the wife is the one actually working and the father is the one staying home. You really have to focus, and I keep saying Judge Katie because she's in the audience, and now we have 13 factors. But she always referred to the Article 134 factors as the 12 commandments. And that's something, I don't know that I ever shared that with her, but that's something that I took to heart as, these are the 12 commandments. This is what we have to follow to make a determination that's in the best interest of children. And absolutely, you want to make sure that to the extent possible, they have frequent and continuing contact with both parents. But you have to also look a little closer into that family union and find out, well, when Billy was sick, who took him to the doctor? When Betty was sick or had cavities, who scheduled all the dentist appointments? Who did all the day-to-day things? Oftentimes it's shared. And when it's shared, that's great. But if it's not shared, then you have to take a closer look at what are the ages of the children, what have they become accustomed to? And again, it's about maintaining that continuity for them, stability, control of their environment, because their environment has totally changed. Now they're going to be in 2 households. You got to struggle to keep the same rules in both households. What's going to make the easiest transition for them? And I think as a judge, if we accept that men and women come before us on equal footing, there's a lot of fathers that have custody. There's a lot of mothers that have custody. You really have to evaluate each individual case and make the decision that's in the best interest of those children. It may not be in the best interest of mom, may not be in the best interest of dad, but if you're making a decision in the best interest of the children, then we are fulfilling our role as judges, and we are helping that family to transition through this process.
Thank you. I have one more question related to custody here, keeping with the 9335 discussion. Joint custody cases, that statute requires the court to designate a domiciliary parent except when there's an implementation order or for other good cause shown. I think we all know that domiciliary parent designation is oftentimes misinterpreted and or misused in practice. What sort of factors are you going to be looking at to determine whether or not there is good cause for naming a domiciliary parent and for making that decision if so?
Well, in terms of the recent jurisprudence, I think the Louisiana Supreme Court has made it pretty clear to us that if the matter comes before you as a contested custody case, it's no longer acceptable to say we've had a week long of custody litigation, but I'm going to go ahead and not designate a domiciliary parent, and I'm going to hope that kumbaya, everybody walks out of the courtroom and starts communicating and doing better. In terms of the domiciliary status, there have been times when I've looked at particular cases, and maybe as a judge, you can help to foster that. if you can get parents out of this cycle of getting back at the other parent and getting them to focus on the practical day-to-day decisions. Who's going to be the child's pediatrician? Well, they're probably coming before the court and they've already figured that out. So you can look at them and say, well, you already agreed. It's Dr. Sibley. Now let's move to the next one. Who's going to be the child's dentist? And if you can start to show them that, well, let's agree on these decisions. Where is the child going to go to school? Is he going to remain in public school? Is she going to go to private school? And have them start to agree on those decisions, then you've now somewhat lessened that authority of the domiciliary parent, and you can allow them to transition into that. I am a firm believer, obviously, in a joint custody situation, parents have an obligation to confer. And I think that is one of the requirements that I would hold them to, because I don't like parents on either side making unilateral decisions and informing the other parent after they've already made the decision. That's a violation of the law. But I think if you can encourage parents to confer, I think oftentimes there will be times when parents will disagree, and obviously the domiciliary parent has the right to make that decision. And it's presumed that that decision is in the best interest of the child. But as a litigator, you know that you always have the right to go back in and challenge that decision. If it's about a medical procedure and there's a difference of opinion between the doctors, you have a right to file a rule with the court, even though the domiciliary parent has decided that we're going to go forward with that surgery. You have a right to come into court and present your evidence as to why this surgery should not be allowed. So I think in the grand scheme of things, I think it's important. I think it's important to have a domiciliary parent. It may be difficult for you and I, Taylor, to agree on what color we should paint this room. So at the end of the day, if we're in charge of painting it, someone's going to have the final say. And if I don't like your decision, I'm going to go tell Judge Katie that you picked the color that was wrong, and I'm going to ask her to change it. But I think you have to designate a domiciliary parent as much as we can encourage them to work together. I still think you need that person with the final say and a presumption that that decision is in the best interest of the child.
Still great. Okay, I believe the question was what factors?
What sort of things are you going to be looking at?
Exactly.
To determine, A, whether or not one needs to be appointed, or do you believe that generally one will, and then what sort of things?
Certainly. Happy to talk about the factors I would consider. Number one, communication skills between the parents. Primary for me. Number two, who handled the medical care and the school care of those kids prior. Which parent has accessibility during school hours, who can be reached by phone, who can handle emergencies. Any past disagreements the parents may have had over school choice, medical choice. I had a case where my client didn't want the child to go to the husband's pediatrician he had when he was little, because she thought he was per se biased. So we never know what their motivation may be. I think also a primary area of interest for me would be how the other parent communicates with the parent when they have the child. So I just had a case where the father, do you inform them immediately of medical treatment? Do you let them know you're headed to the emergency room? Do you let me know, oh, he's been exposed to COVID, that's our new one, and I'm going to get a test, and tell them in a timely fashion what they're doing. I have a case where the father was sleeping, so the stepmother took the kid to the emergency room. Turned out to be a giant abscess, required a 4-day stay in emergency surgery, and biological mother didn't find out until the next day. So those are the factors I think I would look at. Do I think we often need one? Yes. I have had cases where I've done exactly what George did in the joint custody plan. Teenage girl, let's agree on the OBGYN. Let's agree step parents don't go to appointments with the kids. So sometimes you can find areas of agreement that will help as well. But that would be what I would look at to determine whether I needed one in a particular case.
Most parents already agree on the doctors that children are going to see. It's the doctors that kids have always seen. And so what I've done in my practice is to try to look first at what the parents agree on. We've got doctors, that's one thing that parents sometimes disagree on, but if they've seen the same pediatrician for years, they're gonna keep the same pediatrician. So you put that pediatrician and that dentist, pediatric dentist in the plan. Schools, you know, most parents already know where their kids are gonna go to school. There's no disagreement about it. There is sometimes a disagreement because of child support issues. So when parents break up or lose a job, they simply can't afford private school tuition anymore. But for the most part, parents know where their children are going to go to school, whether it's private school or even if it's a public school, they're going to go where they've always been zoned. The other area where parents disagree is extracurricular activities. If a child has always played baseball, well, for God's sakes, put in the plan that the child's going to continue to play baseball. If the child has always danced, put in that the child will continue with dancing. So there are many, many areas of agreement that you can specify in the plan before you even get to the decision of, is there going to be a domiciliary parent? A lot of it, I think Donna is correct, depends on the communication skills of the parents. If we can get these issues resolved quickly without having to wait 2 or 3 months, I believe that that will help reduce some of the acrimony. Because what's happening is people are waiting too long once the divorce process starts to come up with a plan. And they're fighting over custody. They're saying, you can do that, you can't do that. I'm the domiciliary parent. What I say goes, even though they haven't even been to court yet. It's a favorite word of some people. So when I hear those words come out, I know that there's a problem case. And that case may require a parenting coordinator, may require a mental health professional to work with the family.
Donna, I told you an hour. You got time for a couple?
I'm good.
What's that? Okay. Mr. Foster? So- Let's take a break.
Yeah, take a short break.
Is that okay?
5 minutes.
Play some background.
Yeah. All right, moving on. As family court judge, our whoever's elected, you're going to be in protective orders. We have a couple of protective order all-stars in the house, Geraldine and Jonathan, so I'm going to open it up for them and ask questions.
I heard my name being mentioned.
So my question is basically applicable once there's already been a finding that one of the parents is a perpetrator of family violence and the post-separation and family violence relief act applies. As you all know, that statute requires successful completion of a 26-week domestic violence class. The law doesn't really define successful. So my question to each of you is, what would you consider to be successful completion for the parent who's a perpetrator to seek unsupervised visitation?
Yes. Well, I think there are a lot of factors. Again, I keep saying totality of circumstances. It's not just finishing a course. We've talked about this in the context of Clear Start, and I think it follows through in the arena of domestic violence as well. Simply completing it doesn't mean that you're necessarily going to be able to prove that it's in the best interest of the children to lift the supervision or whatever may be in place. I know that I want to know if there have been any other instances. I want to know what's going on during the supervised visits. I want to know how the communication is going. I want to know if there's any abuse or harassment in the text messages. Hasn't that been a change in the law since we've been practicing? A new favorite form of evidence for most of us. The late night tweeting and texting. I would want to know that. I would want to know whatever else that may have been ordered for that individual and the success with which he or she has met it. I think I would want to know about the children. How are the children handling it? So I think it's any evidence that would be pertinent to the best interest of the children and would speak to me about the likelihood of that individual not engaging or perpetrating family violence again.
Geraldine, as a society, we face a horrible problem with domestic violence. And we've had recent problems in our community. And I think people are very concerned about it. When you talk about the Post-Separation Family Violence Relief Act, I think that it requires more than just going to classes. In my view, someone who has a history of domestic violence usually has witnessed violence themselves as a child, which is why they believe it's acceptable to treat women the way they do. I think that it's going to take some fairly deep-seated counseling, not shy counseling where you're just going because you're court required to. And so I think that we need to really look at that. I think that everyone who is in that situation should be in court-ordered counseling. If they don't take it seriously and if they're not progressing, that's something that's going to come out at the hearing. As Donna said, as all of us have said, we're always looking at what's in the child's best interest. If a parent has not dealt with the deep-seated problems that led them to abuse a spouse to begin with, how are they going to be good parents if they continue to show that total lack of respect? Kids don't need to see their dads beating their mom. And we need to make sure that dads aren't going to continue to do that. So I think it's more than just a little program.
I think Gerald and I would echo what these two ladies have said as well. I don't think it's a matter of fact that I've passed the test, I've attended the classes, now I get a certificate and I'm done. I think oftentimes, it's the idea of looking at the totality of the situation. Oftentimes in the domestic abuse cases that I've handled, whether I'm representing the abuser or I'm representing the person, the victim that's being abused, the more you get into the case, you start to see that there's a lot of other issues going on. Oftentimes there's substance abuse issues. Oftentimes there are mental health issues. And I think that if we as a family court can do more to focus on the totality of how to help this family get through this process. Because, the sad part for me is I've seen some horrific domestic abuse cases and represented some women who were horrifically abused. But at the same time, the sad part for me, you could look at these little kids and sometimes they didn't see it. Sometimes it was a situation of the angry person getting drunk or having words and stuff was kept out. And when you look in those children's eyes, they want a relationship with both parents. And if we're focusing on their best interest, then it's our responsibility to help that family. And I think it's not just a certificate. I think we can start to look for other factors that are at play, so that if we do detect a substance abuse issue, then maybe in conjunction with the domestic violence program, they're also required to do some substance abuse treatment or some alcohol treatment. Again, if there's an underlying mental health issue, then that needs to be addressed. I agree with Susan. Oftentimes, a lot of these cases are sort of a family of origin issue. And it's not in any way justifying the domestic violence, but oftentimes these people that are domestically abusing people, they have grown up themselves in that cycle of abuse. And in their mind and in their mental state, it's an acceptable form of communication and interaction with people. And it's our job to figure that out and get them out of that cycle. And it's important for us to also get the victims out of that cycle. I think, one of the things that I've found most interesting is people that are in that cycle at some point have to recognize that oftentimes they're giving that power to the abuser. They don't realize it, but there's a part of that process that continues to cycle. And oftentimes they're in a situation of giving that power of control. So you have to learn them to get them to want to step outside that situation. And then for them to also realize that that's not an acceptable form of communication or interaction or anything else, and help that person deal with issues that they've had as a result of that abuse, so that they can be a happy, healthy person. So they're not going to have post-traumatic stress disorder where they're going to remember this continuing abuse that they may have suffered for 13 years. So as a court system, we have to look at the abuser and make sure he gets the treatment. But we also have to look at the person that's being abused. And again, the children as well. Depending on their ages and what they perceive, we need to proactively address that situation and hopefully get the family through this time of crisis.
Before we go on, I do want to thank the Family Justice Center has been amazing in my experience for supporting the individuals I represent who are victims of domestic abuse. They often are looking to me for that support, and it's a costly support. So I want to thank Geraldine and the staff over there. I have a number of clients that have advocates over there to help them through those times. So.
One more and then we'll get this wrapped up. As a family law judge, you have a wide array of responsibilities. If it's divorces, it's custody, it's all the incidental matters, it's these protective orders, it's community property partitions. As a practitioner, what have you spent most of your time doing? What particular area do you feel you're going to be best suited to serve in?
I think all of us. Sorry.
Maybe it's all the above.
All of the above. When you've done it as long as I have, I've done just about everything that is in family law. I've handled custody, child support, spousal support, community property, domestic abuse issues. I think that as a family court judge, you handle all of those issues, and so that we all have to be familiar with all of those issues. I like to think that because of my 35 years of extensive experience, that I bring a certain sensibility to this. I've dealt with these issues before. It's the area of law that I think is the most important. And I just feel that I can handle any of those issues adequately.
I agree. I do think I'm particularly adept at child custody. I think it's what I started. I've tried 472 trials in my first few years. I mean, that's what you try at legal services. So I think I'm particularly adept at that. If you want to ask how I felt I made the most difference, it was when I volunteered for the to advise legally advised mothers who were giving up parental rights of their children for a reduced fee for the Volunteers of America for adoption. Probably some of the hardest, most selfless acts I've ever seen in my career are sitting with those women and holding their hands. Sometimes it takes an hour, sometimes it takes 12 hours, and it didn't matter how long it takes. I will tell you what I've done to prepare for this position. What I've done is on my own nickel, I've gone through the transparency class. Perhaps I should have warned my clients I might show up in there. That was an interesting moment to walk in there and have two of them sitting in there. I called the organization first and made sure it was okay. Told them I was a judicial candidate and I wanted to go through every class to which a sitting judge could send someone that they thought was appropriate. And so I went through transparenting. In addition, I've done anger choices. I'm a proud certificate holder. They didn't think it was best for me to attend the Best Moms class, so I didn't do that. I've also met with 2 child psychologists, again on my own nickel, talking about these issues. I'm very comfortable talking to children and relating to children if they're going to be witnesses for me or if I need information about what's going on. But it's a whole different position. You're required to do a Watermeyer hearing. So I've done that as well to prepare for this position.
I guess to echo what everyone else has said, in nearly 30 years of practice, I've handled every type of case. I've represented mothers and got them in custody. I've represented fathers and gotten fathers' custody. I've represented grandparents and gotten grandparents' custody. Community property partitions, child support, spouse support. I think for me personally, I'm very, and I see people in the room that I've actually litigated again, and I would hope that they would agree that when it comes to my passion, I am passionate about custody cases. I'm not sure if I can point necessarily where that comes from, except to say, I'm passionate about our boys. I was a soccer coach. I was a baseball coach. I coached t-ball. My sons were not always the best athletes, but they were team players. All the parents that I had the pleasure of coaching their kids through all those years, they placed their trust in me. So when it comes to children, I am passionate about children. I'm passionate about custody cases. We've all had friends who have gone through divorce. I try to counsel my friends, focus on your kids, focus on your kids, focus on your kids. And get all the nonsense behind you, get all the litigation behind you, and get back to being a parent, because you're going to be a parent till your son or daughter graduates from high school. And guess what? My dad will tell you it doesn't end there. He was involved in college. He was involved in law school as a child of parents who divorced when I was a senior in high school. It's not fun. You have to decide, am I going to mom's for Christmas? Am I going to dad's for Christmas? Or is everybody going to get along? And I'm pleased to say, love my parents to death. And they totally transitioned. And how great for me in college that I could actually come back home, and although my parents were divorced, we did Thanksgiving together because it meant that much to my parents. They could put their differences aside. And I think as judges, if we can push and massage and get people in that direction, I think families will be better for it. And I think the kids will be better for it, and the kids will be stronger and happier and healthier. And they'll be able to pursue relationships when they get older, because we as parents have made it better for them, or we as judges have made it better for them. And I think that's our role as parents. And I think that's our role as family court judges. Help this family get past this trauma and figure out a way for them to get along so they can go to graduation together. You know, we've all had cases. I can't tell you the number of phone calls that you get to say, my husband is sitting next to me at the T-ball game. And the issue is, well, if you're both focusing on your son or daughter playing T-ball, what does it matter where you're sitting? And people have to get past that, and I think they can. And I think if we can transition them, families will be better.
All right, last one. Really 2 or 3 minutes here, because I know y'all have to go. Anything else y'all want the voters to know? Any closing remarks?
I sincerely ask for your vote and your support. This is the area law that I love. I've been involved in family law for all 35 years of my practice. I truly want to continue to serve our community in this position. I believe that I have the best qualities for this position with the extensive experience that I have. That wraps it up.
I believe I'm best suited for this position for a number of reasons. Number one, I think I'll respect every litigant and every attorney that comes in front of me and treat you equally, regardless of who you are, who represents you, and where you're from. And I think I have a 26-year history of practice in this town to support that. In addition, I will not play favorites. Can't be done. It's not allowed. Number two, I want to put children first, and that means somebody's going to be upset, and I know it. How many of us have tried relocation cases? And someone's going to be devastated. But we have to put the children first and make the best interest of the children primary, regardless of where it comes. We have to make a decision for finality and move on, because as we've talked about numerous times tonight, we have huge lists coming behind us. So someone has to sit in judgment, make a decision, move on. And last, I can tell you that I think that I'm particularly suited because of my my communication skills. I think those of you that have litigated with me know that I listen well. And I think that's critical so that your clients feel that they've been heard. I can't tell you, I'm sure you've experienced this. I've had clients that don't want to appeal because they feel like they got a fair shot and someone listened. And that's what I can pledge to those of you here and watching at home that I'll do. So I would appreciate your support and vote on November 3rd.
I guess I'll take a little bit different approach. You know, one of the things that's been interesting for me during this campaign is oftentimes people come and say, I need a number. You know, how many family court cases have you heard? You said you've been practicing almost 30 years. You said you were licensed in 1991. So in preparation for tonight, I was fearful of being asked that question. And what I was not aware is Lafayette Parish, for instance, you can go to the clerk of court and you can say, I want to see how many divorce, family, custody, protective order, any cases involving children. I want to see how many cases George Knox has handled. So I asked the clerk's office to run those numbers for me. And I guess not to my surprise, because I knew there had been a many in Lafayette. And obviously I go to Vermilion, I go to the 27th Judicial District. I go to Iberia, the 16th Judicial District, but just in Lafayette alone, I ran those numbers and it came back that I've actually handled 506 family law cases since 1991. Those of you who know me as a litigator, next question necessarily comes, well, I'm curious, how many has Susan handled? Susan's actually been practicing since 1985. So I got Susan's number and it came back 577. And I expected that. I started in 91, she's in 85. You know, and I ran Donut's numbers. And from 1991 forward, she's actually handled 90 family law cases. And so, you know, I think you have to look closely at the experience of the candidate. You have to look, you know, not only at their work ethic in terms of, you know, how often are they in family court, how often are they actually dealing with families. And I've said it, you know, I've said it time and time again. You know, I want to bring my experience, you know, not only as a family law attorney, but I want to bring my experience as a parent. I think that is critical to this role. It makes me empathetic to families. My family has not been without strife. We've gone through a lot of things as a family, but we've come through those challenges. And I guess lastly, I just want to say, and for all of the younger attorneys, I do hope that one of these days, each of you gets the opportunity to run for judge. I don't mean that in a mean way. I can tell you that it has just been a phenomenal experience for me. My dad passed away 7 years ago. He was my best friend. He was the best man in my wedding. And I'm filling up at the gas station in Youngsville, and somebody pulls up and says, "Are you John Knox's son?" And I said, "Yes, sir, I am." He said, "Well, I played tennis with your dad at Beaver Park. And your dad was a phenomenal guy. And if you're his son, then I'm voting for you." And it made me feel good that that was a part of my dad that I've always carried with me, and that I hope I carry that tradition. I've run into people that, my little brother's an attorney in New York. I've run into people that went to Green Tea Linden Elementary with him. My older brother's a psychiatrist in Colorado. I've run into people that went to Como High School with him. My mother went to Youngsville High School. I've seen her friends. I've seen people that worked for my grandfather, who was a sugarcane foreman. I share, and I tend to go long, but I just share one story. I was coming home. We had been putting up signs, and I pulled in the driveway, and a lady pulled in behind me and said, "George, I need your signs," as though she knew me. And if anybody knows me, Youngsville, we still leave our doors locked, our garage door open. And I said, "I'd be happy to get you some signs." And I'm talking to her, and she's so enthusiastic about the campaign, and I'm trying to place her. And so she hands me a card. She says, "I'm a counselor now, and you've got my family's support. We've known you all those years, and we're here to back you." And so as she's pulling out the driveway with her mother, who I thought looked familiar as well, I looked down at her card, and it was actually somebody that I went to Green Tea Linden with in the 2nd grade. And I kid you not, I had not seen her in 40 plus years. And it was heartwarming to me that she was so proactive about this campaign. So for the younger attorneys, I encourage everybody to try it, if you're so inclined. It is a good experience. It's a costly experience. I recognize that, unfortunately. But it helps you learn so much more about the system. It helps you talk so much more to other attorneys and get their input on ways to improve the system. I've heard great ideas tonight in terms of improving the system. And I do think if we work together, we can make it a better system for all the families in Acadiana.
All right, guys, thank you so much. I know it's time to share. We encourage